Oh. Court is now open. You may be seated.
Hi, good morning. So I just saw a transcript that was placed here on maybe referenced this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this? Okay.
With regard to Dr. Crosby and Ms. Coon, as the
Speak into a microphone.
Sorry?
Speak into a microphone.
With regard to Dr. Crosby and Ms. Coon, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony. All right. As it relates to Dr. Welcher, the scope of his testimony, our request is that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolf, as well as Dr. Rentschler, are not allowed to speak to the credibility of
anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. La Posada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. La Posada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in the case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. Lopesada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor.
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Lopesada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it. I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the...
All right, I might have a different page 7. So my page 7, okay. Okay, yep.
Dr. Lopesada's proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson. Great. Okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great. All right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony. Basically, she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology that she uses. Medical school classes, I didn't mention the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I don't see any opinion unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others, have to deal with pattern recognition. The methodology involved with pattern recognition.
How about dog bites?
Dog bites, specifically 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you. Okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5. She's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of the jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her an absence of jury or a voir dire.
No, that's where, if we want to compare apples to apples, Dr. Wolf, Azek Wolf, was allowed to specifically testify to the wound pattern, his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the reports. We didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition. At least in his mind, you can cross-examine that line. There is no requirement that the Commonwealth have every single case that Dr. Labasada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Alessi, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire. I just wanted to short-circuit it. But
So, all right, so let's go on to page 17.
Commonwealth has an objection to the third line, Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that properly.
What do you say, Mr. Jackson?
No, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Thousands, multiple thousands.
So
But if she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to introduce.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, or starting with the first sentence, yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component of tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the movement patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay,
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian, incident, or accident.
Okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in. What I said you could put in can come in, and the rest cannot. We could.
And this, for point of clarification, if I ask her, would you expect? I'm just going to make it a hypothetical. Would you expect if his legs were contacted by a moving vehicle? Would you expect to see a bruise or contusion?
What do you say about that?
I object. One, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Lavisada do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Cromwell versus Tompkins, appeals court. I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Lavisada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another court that she's not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the ARPA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training experience.
I'm sorry, where?
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by a regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
All right. Sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called, and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about blood-stain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's product. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify about.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lopesada?
No, not
Through whom?
Yeah, can I with regard to these photos, well, ultimately, the Lopesada will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be he took measurements from the street to the various entrances to 34 Fairview. I would just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows.
How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a loading defense in this case. We are alleging anyone other than Karen Reed. The Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are photos are introduced on that Bowden issue to say that there was evidence in the house. If the police only went in there, they would have seen that, and that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show Dr. Laposada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of the movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Brian Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I would argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car because they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative. It is baseless. They want to take that baseless argument and then bootstrap it to Dr. Laposada to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay. So,
The only other thing, just just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
All right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolf?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Lopez-Hada. All right, bring him on over, please.
all persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your Kenneth, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning, jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning, so thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Okay, thank you. Can we have Dr. Ward, please?
Chair, I'll remind you, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolf, thank you for joining us again this morning. I'd like to draw your attention to a picture. May I approach, John?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes.
You were shown this photograph last week, is that right?
Correct.
By Mr. Brennan, correct?
Correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes.
Under questioning by Mr. Brennan?
Yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29-mile-per-hour impact test.
And does that appear to be a true and accurate photograph of the condition of the dummy following that 29-mile-an-hour crash test?
Yes.
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the fourth one.
218, exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
Yes.
Dr. Worf, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face?
there.
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself, on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to full frame. The second image I'd like you to take a look at. If we can have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Okay. Exhibit 219.
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? You see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
Okay. The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220.
Permission to display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes, and again, that asphalt material transfer that you see on the front.
Can you go up back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes.
Are those the chin and nose defects that you saw?
Yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29-mile-per-hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29-mile-an-hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy shoes?
They are still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question.
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29-mile-per-hour impact.
We can take that down. May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29-mile-per-hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29-mile-an-hour impact?
Yes, and I should be more specific. It's post the 29-mile-per-hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at?
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the photograph that we were just talking about?
Yes.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist?
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm you can touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6, so I'm not sure of the kind of the final number he landed on.
Does
Sustained estimate. Ask the question. Strike on the end.
Does 11.86 sound right?
Yes.
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers.
You're looking at just the difference between those two?
Subtract
Okay.
9.38.
Yep. 2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter, in terms of percentage, the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%? Is 23% smaller or, no, or larger than 26%?
Sustain. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
.21.
In percentages?
21%.
Thank you. Was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it. Sorry.
Not yet.
You see it now?
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolf?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
you were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the form. Ask it differently.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that form.
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your Honor,
understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay. Whatever's easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared.
Correct.
Is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm.
Okay.
That's being transferred.
Understood. 3,415.68. Is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38.
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5.
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm?
Objection.
Sustained.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29 mile an hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
Uh-huh. And so you were suggesting that that is just a number pulled out of thin air, right? Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds. Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is...
So it's sustained. Ask the question differently.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated for use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile. Isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that because, again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50 percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and they're 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused. I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I don't have the percentage off the top of my head.
So if you take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds.
Okay. Close to 9.38?
9.37.
Okay. Now when you have 216 pounds, 5.48%.
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you where did Brennan get those numbers from, you said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes.
You testified before under oath in this case, didn't you?
Correct.
And when you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Objection.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just... Okay. And you used the calculator to help you, didn't you?
I did, yes.
Calculator works.
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
didn't ask you. I'm asking if you would agree with that.
Can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Yes.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct. Yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints?
No.
You didn't explain it to the jury that there's a difference and weight matters?
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because, again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your world, in your profession, that suggest or state that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Renfro. Can I finish, please?
No.
Objection.
Okay, so, no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
Right. And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human that pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in tests A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones that you use to test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider that he wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever? Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. We worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yeah?
Correct.
The other one testifying, giving opinions to this jury, yes?
Yes.
The other one asking them to rely on your experience and training, true?
Correct.
The other one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
Well, when wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
every single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection is sustained.
I'll move on.
The objection is sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm going to see you inside.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
Oh, at some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just moved to the side, yes.
And so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if
when
I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved with the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity?
The operative word here is push. And so, do you like to agree with me? You could disagree with me. Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding Test F, now you used Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
Right. I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did your test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet. You used a forklift.
Because, again, the purpose of the test was to evaluate, we talked a lot about those time frames, right, that 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that, 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet. You used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Okay. And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. And the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, Doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Okay. Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any tail light fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
In finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have Exhibit 201D, please? Do you know what this is, Doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you talked about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talking about the hand?
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection.
Beyond the scope, Mr. Chairman.
A few more questions, Dr. Wolf. You showed us holes in Randy's sweatshirt from Test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the.
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir. Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. You see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor. Very good. If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
The objection sustained.
You were asked, give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
So sustained.
How much? What was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection.
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were...
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know. He was asked questions.
That's the end of that, Mr. Jackson.
Do you have the, Mr. Wolk, do you have the picture of the tin? The TIN, tin, the little round tin? Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all of the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
And you indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
Okay. In your testing, how long did it take the Hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again. About
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is...
Ask the question.
If the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, on the source.
No.
Dr. Rentschler, do you agree with that?
Objection.
So I'm going to allow it strike source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize it is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Do you agree with that?
I'm going to allow it.
I need to
I'm going to read this one more time, okay?
Okay.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please. And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess. We'll see you in about 20 minutes.
Please rise for the jury. Right this way.
All right, so we're not going to do the voir dire right now of Dr. Lapasada because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the director, Dr. Lapasada? Is that you, Mr. Jackson?
Yes.
All right, so what I would ask you to do is not do anything on your direct examination with Dr. Lapasada that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire. But I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you? Can you use the hour?
I can get her credentials, but Your Honor, half of her credentials are the fact that she's an expert in dog bites and an expert in motor vehicle. I can get her education, training, background.
Okay, is that all in? Is that all in her resume?
It's all in her. It's all going to be in her direct examination.
No. My question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says the word dog bites anywhere in her resume. No.
We have absolutely no notice.
But the courses that reference dog bites are listed.
Say that again.
The courses that reference her teaching dog bite issue and pattern recognition, they're listed in the resume.
All right. We'll see you at 12. All right, so I'm told counsel wanted to see me.
Your Honor, an issue has arisen related to the cross-examination or re-cross-examination of the last witness, and Mr. Alessi would like to address the court in detail about that.
All right, so the last witness was your witness. Is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the court on this.
Okay. What do you want to tell me, Mr. Leslie?
Bear with me a moment, Your Honor. I need to put on evidence gloves. Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the Hoodie, and this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the Hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked the first document, and I want to get the specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the Hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the Hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Okay.
That is the back of the Hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ, Friday identification.
Give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the Hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a Hoodie sweatshirt, went to the back of the Hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the Hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized that line of question was going to be asked was when Mr. Brennan pulled the case out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
Absolutely, Your
Mr.
Honor.
Leslie.
So, here is the back of the hoodie.
All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist, and I'm going to get back to this in a moment. But I would like to do it, and certainly entertain any of Your Honor's questions, but in a logical order.
Sure, so I'm not... what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right, thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the Hoodie, I believe, is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the Hoodie before the criminalist started her work with the cuts. There are no cuts to why, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the Hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see. Point out to me where it says, where it shows the back.
This is the back. So you can see the back of the Hoodie. That's the back of the Hoodie head. And then you can see the various... Let me just get a check on this, Your Honor. I'm not...
Right. Mr. Brennan, you should come up and look at this as well.
Thank you.
And I'm
So, Mr. Wesson, stay here.
yes.
All right, so this is why. I didn't see where Ms. Captain said that she cut it off. It was showing here, Mr. Wesson, says exterior front.
Can I get the check?
Labeled cuttings.
Pardon me?
They're labeled cuttings.
Right, but if I can, Your Honor,
Sure.
I want to clarify this. Yes, are you willing, Mr. Watt? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
Well, yes, it may have printed the wrong page. I can do it, but Mr. Wolf, can you print the back? And Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now. We printed. We wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
I may, Your Honor, I'm advised it'll take 2 minutes because it has to go
All
through.
right, so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it get marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
Thank you, Madam Court Reporter. Sure. And here's another document, chain of custody document. Well, Mr. Brennan is reviewing that. When I head to Madam Court Reporter, the chain of custody document for these, and that he marked is the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
Do you need this, Mr. Lessie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you. Okay.
So if I could have one set, that would be great. Yeah, Your Honor. Thank you.
I still do not have ZZZ.
Nor do I. I don't need them.
All right. Thank you. Okay, go ahead, Mr. Lessie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88. He holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett. She's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
right,
that.
That's right, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right. Thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion, Mr. Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Alessi, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates.
Your Honor, on or about May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's what.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instructions for Your Honor.
Right. So I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up. Because that's what happened.
Yes. Yes.
These holes in the
Yes.
back.
Yes.
Okay, thank you. So that's number one as part of the stipulation. And then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Alessi. I'm not showing disrespect to the court.
Okay.
Of course we were listening.
All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, we might need to have it marked. But we don't need to do that right this second.
Okay.
May I approach Mr. McDermott with exhibit
Yes.
88?
Thank you.
All right, thank you. I'm sorry. Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
Counsel, this is Exhibit 223.
And Your Honor, I would hold it as Your Honor begins to read. Is that consistent with Your Honor's expectation?
No, I want you to hold it up with the back.
What would you like me to start with?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott, or the court officer.
Yes.
Thank you.
Court officer.
Bear with me a moment, Your Honor. I'm going to put on the...
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here, but she's on next. We're going to call
John Tiedemann.
For just the measurements?
No measurements.
Your Honor, if I could be able to show the exhibits from Ms. Hartnett, or the cuts, along with the next step of instruction, to show the cuts that were made by Ms. Hartnett. Along with
Well, I say it, and I'm going to tell her what they are, so.
Please be seated. Court is in session.
All right. Jurors, I appreciate your patience. Mr. Alessi, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag. So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll... Mr. Yannetti, your next witness, please.
John Tiedemann.
You solemnly swear the evidence to give to the court and jury in the case now is here to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
All right, good afternoon.
Good afternoon.
Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tiedemann. It's T-E-D-E-M-A-N.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start forum investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay. And when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right. And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, and can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolf, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolf? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wolf can put the lights on. May I approach the witness, Your Honor?
Yes.
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the two car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit, does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Okay, Mr. Wolk, whenever you're ready, if you can display that portion. Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
Hey, please rise for the jury. Right this way, please.
So you can just follow the jury's. Excellent. Thank you.
You may be seated.
All right, so we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right, so can we get Dr. LaPosada in here? We'll do a very brief voir dire of her.
You're going to step up, face the clerk, and raise your right hand.
Do you solemnly swear the evidence you have before the court in case you have the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, good afternoon, Doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence. Those two areas. And if there is support or methodology in Dr. LaPosada's resume to point to exactly where that is. Okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth LaPosada. That's spelled L-A-P-O-S-A-T-A.
Dr. LaPosada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. LaPosada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
at the
medical school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken.
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals. Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist? Absolutely. Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically? Oh, yes, they do. In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds? Yes, I have. When was the last time you did that? Let's see, it would be in the course in the medical school. Would have been several years ago. Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds? Yes. So you've seen them in person? Yes, I have. Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites? Yes. When was that? The last one I can recall was a federal case involving questions of a police dog. Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw? Yes. Did the court qualify you to speak on that issue in court? Yes. Did you, in fact, testify in furtherance of your opinions and conclusions in that case? I did. I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents? Yes. How many times would you say you've performed an autopsy on those issues? Hundreds, maybe even 1,000. Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology? Yes, it is, unfortunately. Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents? Yes. And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents? Mm-hmm. Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records. the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
Good afternoon, Dr. La Posada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, starting in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites early
Yes,
on?
yes.
And
I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you
Well,
completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there's our lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lapasada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on this case?
in your report relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
In my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
they're
that
taught differently, obviously.
would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a medical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around, I look at the body, I look at blood stain patterns, I look at damage to the car, and then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you have been qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right. Thank you, Dr. Laposada.
No, you're welcome.
So can I just ask Dr.
Yes.
Laposada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions? All right. You are all set and asked you to step down, Dr. Laposada. We'll get to you sometime this afternoon.
Okay. Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Easily. Yes. Your Honor, I'll make this very brief.
Okay.
Dr. Laposada is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many, many, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s. dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the two subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these two subjects that's before the bench right now than somebody with Dr. LaPosada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do not think that Dr. LaPosada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training, seminar, or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. LaPosada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. LaPosada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
Can I briefly respond?
Okay.
She was, Mr. Brennan suggests that, well, she's only been qualified in one court, federal court. The federal government, the federal judge that was handling that case, qualified her as a dog bite expert in that case. That is not a small thing.
That, as a matter of fact, it's a very big thing for Dr. LaPosada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognition. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. LaPosada brings much, much, much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. LaPosada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right.
I'll submit.
Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All rise for the court, please. Court back to session. You may be seated.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right, so my rulings are very similar that they were this morning. So first of all, on the Darbert analysis regarding Dr. LaPasada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made, specifically not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. LaPasada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. LaPasada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now moving on to the testimony regarding not being consistent with a motor vehicle strike, I find that Dr. LaPasada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17, the first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in. In the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that, in review of the Tompkins case, that first sentence stays out because to me it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. LaPasada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of the, there's no PowerPoint with this, Mr. Jackson, right?
There's no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry?
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now with
All right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in. And
my suggestion, we have to finish with that otherwise.
right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I will do is my intention. I will go through her prediction. That will take me a good amount of time. I will go through the part of her initial analysis that will not include any of the photos, but I may need overnight to actually go through the court's ruling. It's very specific, and I want to be as
Okay, so
that as possible.
let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So we'll deal with this tomorrow, with the photographs tomorrow.
I just want to let the court know, I'm not wasting the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. This jury, you can tell just by looking at this jury, they're fed up. So.
Your Honor, the only thing I want to put on record is, with regards to the court's ruling, I do want the record to reflect that is obviously it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Papassada. They had a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 485.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know the point I can make.
You just made it.
I made it ish.
Okay. Okay.
The point is.
Go ahead, real quick.
The point is, the Commonwealth has not explained the delay
So.
in making this motion. They have, and we're playing by the same rules, Judge.
So the basis of my ruling was not late disclosure. Okay. Late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They've had since March to object. They blew the motion in limine time, and then they come in just before Dr.
All right.
Papassada testifies, and now they're sort of sandbagging this and getting the courtrooms against us. So I want to make sure that the record is imminently clear.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during the proffering of testimony. There's no foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify that the defense could object if the foundation weren't properly laid. So, bring them in, please.
Rise from jury. Court is in session. Please be seated.
Jurors, you have been extraordinarily patient with us today. We're going to go straight through until 4 o'clock, and we're going to make every effort to not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Giannetti, is your witness ready?
Mr.
All right, Mr. Tedman, whenever you're ready, sir.
Thank you.
Thank you, Your Honor. Sir, before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? not that one, the one that we discussed right before court. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the two rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left of this photo, particularly with regard to the third entrance, the one in red. Could you describe that?
Yes. So it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay. So basically from the street, you don't have to enter the house. You can go into the garage directly.
That is directly into the garage, yes.
All right. And as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes.
And that is a westerly direction toward the house, sir?
Correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustain. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door. You took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is.
Sir, are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those three street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the two connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay. And if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
I'd be facing west.
If I may have a moment, please.
Okay.
Further questions? Thank you very much, sir.
Thank you.
Questions?
Yes.
Good afternoon, sir.
Good afternoon.
You had a wheel to measure,
Correct.
and so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door,
To the main front door to the far left, yes.
and that was about 63 feet?
I believe it was 65 feet, something like that. I have
65?
my notes. Yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
Except one way.
Correct.
And back is another 78 feet.
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurement. I'm not sure.
Do you have it in a report that you can look at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you can share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway to any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. From the measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
I have nothing further.
All right, you are all set, sir. Thank you very much.
Thank you.
Okay, Mr. Jackson.
Thank you, Your Honor. We would ask the court to ask Dr. Elizabeth Lombardo to join us.
Okay.
Step up, face the clerk, and raise your right hand, please.
You solemnly swear the evidence you give to the court and jury in the case now and hearing is the truth, the whole truth, and nothing but the truth, so help me God.
I do.
Good afternoon, Doctor.
Good afternoon, Your Honor.
May I inquire?
Yes. And Dr. Lepasada, please speak right into that microphone,
I
okay?
will.
Thank you.
Doctor, can you please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Lapasada, spelled L-A-P-O-S-A-T-A.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Okay. Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor, and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since 1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second-year medical students. I teach a lecture in diseases of the heart, cardiomyopathy, and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents, come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death. And that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, the whole gamut of ways people can die unnaturally.
And what type, to contrast that, what types of cases did you work on during your anatomic pathology residency?
There you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Were you a research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
Old habits.
Yeah.
What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, excuse me, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff, so running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as the co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending when?
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. excuse me, I'm so sorry. In 1999, the Egypt Air 990 took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner, or the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic Station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful, in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task force. Before you became the chief medical examiner in Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yes. So after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Dr. La Posada, can we put dates on that? Assistant medical examiner in St. Louis, from when to when? Do you remember?
Oh, my. Let's see. May I look at my CV?
Sure. With the court's permission.
Yes. Okay. Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. La Posada, have you held any faculty positions in the field of forensic pathology that qualify you as an expert in this case?
Yes, every medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital University of Pennsylvania, in Philadelphia, and in Rhode Island.
Let's talk about those one at a time. Describe your teaching responsibilities at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Did you do some sort of a forensic pathology rotation for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart.
And what is myocarditis?
Inflammation of the heart muscle.
Did you ever teach or lecture on those issues?
Yes, I teach every year. I teach the second-year medical students about those heart diseases.
Have you ever taught anatomy and physiology to EMTs?
Yes.
Or in the EMT setting?
Yes.
And what about a class known as the 2-hour primer on forensic pathology?
I've taught a lot. I don't recall that particular.
How about pathology residents morning conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomedical forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012?
Correct.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences?
Correct.
Okay, yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Okay. Without going into every single class that you taught, did you teach from 1987 to 1991, attending staff medical pathology?
Yes.
What is that? Just a general outline of what that teaching course was.
That's when I was at the Hospital University of Pennsylvania. I ran the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine, in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in forensic pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Over 40 years, maybe several hundred.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode Island, yes.
Have I left anything out?
Did you say Massachusetts?
I did.
Okay, then
we
you're
started
fine.
with Massachusetts.
Okay, you're fine.
What types of topics have you qualified to testify about as an expert forensic and anatomic pathologist?
Really, anything that has to do with circumstances and cause of death. So it doesn't really matter, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records, and we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You want to make it for one brief.
Dr. Lepisano,
Yes.
I'm going to ask you to step down and you can go back with the court officer into that back room.
Okay, certainly.
And jurors, rather than send you downstairs and back up the stairs to come back in 5 minutes, I'm gonna sit here, you all can sit here, we're just gonna be in recess for 5 minutes while we sit. You can have a seat here, thank you.
May I inquire?
Yes.
Thank you. Dr. Lepisano, you mentioned several topics about which you testified and qualified as an expert. Testified about it as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology puts forth examinations that are a 2-day examination in the various disciplines of pathology. And if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic bloodstain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took training to become an EMT.
Have you received a number of honors and awards in the field of forensic pathology?
I have.
What do those awards include?
May I look at my CV again? Sure. Thank you. I had teaching awards from Brown University School of Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was nominated for Woman of the Year in Rhode Island for my work as chief medical examiner in improving the office and handling those 2 mass disasters. I was honored by Victims' Rights and Services Awards because I've always been aware of the fact that as a forensic pathologist, I am the last doctor this person is going to have, so I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
If you could pull the microphone a little closer to your chin.
It's very hard because the chair doesn't push it.
Oh, the chair doesn't move. Okay.
Oh, I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. LaPosada. What is the American Academy of Forensic Sciences?
That's one of our medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were you the chairman of Forensic Science Research, the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes.
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Were you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Rhode Island Medical Women's Association, what is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes.
Ultimately, were you elected as the president of that organization?
I was.
Rhode Island Medical Society, what is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes.
And what about the Massachusetts Medical Legal Society?
Yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No.
When it was up and running, you were a member in good standing?
Yes.
Good, good. Pennsylvania Association of Pathologists, what about that?
Yes, when I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes.
Have you served on any editorial boards of any scholarly journals or publications? Tell me about that.
I've reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner Journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes.
Is that one of the medical journals that is used throughout the country by other medical professionals, other medical examiners?
Yes.
It's a resource?
Yes.
And a text?
Correct.
Have you authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I got here. Yeah, I've written chapters in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine. Let's see. Alcohol metabolism in the heart, I mentioned. Let's see. And so I've published 22 papers, and I've written several chapters.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your education, training, background, publications, teaching positions, and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death, and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death for why the body stops functioning, but there's only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those 5 main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those 5 categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural, suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct? What types of information does a medical examiner, a forensic pathologist consider in making these determinations between natural, accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis, and then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000, and then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies, if you were to estimate, over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining and identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yes, so looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be a gunshot, something, does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of a body?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen, and depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. La Posada, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head, specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There, in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for forensic pathologists to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
Oh, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, And then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern, and that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had a massive skull fractures that originated, started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. Laposada, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contre coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contre coup, where the brain slaps forward, and when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids, so it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see your sidebar here.
May I inquire?
Yes.
Thank you. Dr. LaPosada, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be it's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again. May we approach? This is probably a good time. We talked about it at the sidebar.
Can you do anything to fill up the jury's time for the next 10 minutes, and then we can do this?
Not without what we discussed at sidebar.
Come on up for a minute, okay? Both of you, come on up quickly. I'm told that we're still on track. We will start. I'm going to have you show up a half hour later than we normally do because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting as much as you've waited today. So if you've taken half an hour more to get in here, whatever time we normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without sidebar conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful again with your social media use, and we'll see you tomorrow. So, Dr. Lapasati,
Yes.
you can step right up, just follow the jury, and we'll see you tomorrow morning. If you be here, make sure you're ready to go at 9.
I'll be here. Thank you, Your Honor.
May be seated.
All right, so can you argue the Commonwealth's motion that I received this morning regarding Dr. Renshaw? Can we just do that now? Okay. No, that's fine. So we'll do that first thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take care of the photographs, whatever photographs in her report you intend to put in.
Is the court hasn't made the order yet, but it seemed like the court was leaning toward not allowing any text on the photographs?
So that was just at a quick review. I had not I just read the content, the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with gastric mucosa.
I think those have been shown, and I know the Wisniewski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
Understood.
They're,
The stomach lining is a bigger issue, and then some photographs in evidence, like the car that's probably already in, things of that nature. So all
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything, and they are extremely inflammatory.
I'm not looking to enter the. I'm not looking to get those.
All right, the photos on page 6, I believe, are already in evidence. So this is,
That's a Lucas machine.
right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in, or just the photograph that's got color to it?
I'd actually like all of it in. She will explain what effect it has on the pancreas and stomach lining. It's in it to reduce the spots for lack of.
Okay.
Page 14, I think these are all in evidence otherwise, but I would like this particular, it's all in one spot.
Hold on 1 second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs. This is all for number 1. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
The right sleeve. So I'd like to use this because it speaks to her evaluation of these particular.
All right. How does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood staining on fabric around the puncture.
Yes.
I'm assuming she's getting that from the lab. They tested it.
Okay. I don't recall testimony regarding. It doesn't mean it didn't happen. I just don't recall it. So I just need to know the source. All right.
Pull that out.
I have no objections to the photos. I do have an objection. Yeah, go with the photos.
Okay. 13A and 13B?
Yes.
Yep, so 13B's out because of the dog bite. Let me see. All right. So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing, the opinion blood staining.
I have no issue with blood stain coming out. Outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Page 53 in the report.
What page?
I don't have a page number, Judge. Hold it up.
Page 5.
Page 5. It shows the cross-section of the brainstem.
That's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is installed. It's highly graphic. This is no more graphic than the supplement.
I disagree, but why does she have to use this photograph?
In furtherance of her determination of the constitutional injury, it supports that. I didn't put it in during that conversation.
Okay. There's no contention that coup contra coup is the cause of the brain injury, correct?
There is contention that the coup contra coup is. Yes, that is the contention. I don't think there's any controversy. That's what the.
I thought that's what Dr. Wolf testified to, no?
Consistent. I don't think there's any disagreement.
Right. So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the brainstem, which talks about whether or not he was immediately incapacitated or not immediately incapacitated.
Okay.
Issue.
No, I understand that's an issue. Okay.
It is an issue.
Yeah. Okay. What else, Mr. Jackson?
I think you've seen this, Your Honor, and I'm looking at this figure 5. So there's these spots.
Yeah, I think that's already in evidence, isn't it?
It is, but not the. Mr. Leslie's saying it's only a chunk at this point.
I recall it was up, and I usually don't put up chalks, but okay. Excuse me?
Mr. Alessi. Can you say it again? Thanks.
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, and my understanding is it's marked as an exhibit only. It was used as charged, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think. We'll know. Okay. What are those? All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9. Just attendant to these two photographs are attendant to the Lucas machine.
So you're saying 9 in evidence or 9 on the form? 9A and B. Is there an objection to these, Mr. Brennan? Going to the Lucas compression device. There's one on someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay. All right. How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Lapasada.
I would guess I probably am going to finish under an hour.
Okay. Any idea, Mr. Brennan?
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Lapasada's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are in the case. It's improper opinions and assumes facts not evidence and improperly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues to the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are. Each slide that we have any objections to, there's quite a few.
All right, so I'll look through that tonight, but the same restrictions will be you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a close look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either.
If we're done.
Okay.
4 documents. These are documents that are attendant to Dr. Lapasada's opinion and conclusions concerning the dog bites.
Okay, so
I'd like to have those identified for the record.
yes. So we'll make that part of the record. I need a clean copy of Dr. Lapasada's report and her resume for the same purpose.
And her resume.
Yes.
Okay. I'll have those 2 by
Okay.
Just finally, the redacted version of the 34 Fairview post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half. 2 hours. being corrected. 3 hours. 4? She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's going to be a whole thing. I mean, between us and cross-examination.
All right. So I told you all the other day I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial, Judge.
I understand. All right.
I have one more item when Your Honor is ready.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
That's my expectation.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right. That would be for everything, including Dr. Wrench,
I'm sorry.
Dr. Welcher?
Dr. Welcher, and then the DNA, all those 2 witnesses. I think it should be done in less than an hour.
All right. So will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last, but it all depends on when we can get the DNA people. And Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people in first. But we haven't had confirmation on the flight.
All right, because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at some point. If something happened with Dr. Lapazzato, they were going to be different. We heard that at side.
Oh, okay, so the motion that I allowed was Ms. Kuhn. I believe Dr. Gillespie's name was in there.
Hartnett.
And Ms. Hartnett. Okay.
So that's the excessive scope of Dr. Welcher or the scope of the rebuttal witnesses for the Commonwealth.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right?
Correct.
Okay.
And nor Dr. Crosby, as I understand.
Or Dr. Crosby. Right.
That's what I got.
Yeah.
I think there's.
Sorry, I know.
Well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor, we want to alert you to, we will come tomorrow with a suggestion with regard to the curative instruction that was given to the court today. We're going to come tomorrow with an ask to be heard on that. And we can, so we're going to come in with that. What happened, what was discussed before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Lessie.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on that. Don't want to keep the staff later today.
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay. All right. Thank you.
All rise for the court, please.